And now our last speaker in this panel is Dr. Avital Margalit from Sapir Academic College, who will be speaking about check-in, check-out, communities, and their members' property.
Yeah, so as everyone else, I thank you, Shai, for the invitation. And as you can see from the title of my paper, you can understand the circumstance under which I came about it. He urged me to give him a title, and we were just on a journey. So check-in versus check-out, it will be changed probably. It is common for academics to begin their presentation by statement that their project is in its initial stages. It might be true. In other times, it serves kind of a protective or defense mechanism against harsh criticism. So my project is not even its initial stages, but I urge you to criticize, give me ideas, suggestion for further reading and everything. All right. So questions about entry to and exit from communities. Please don't. Okay, thanks. Thanks. Questions about entry to and exit from communities, starting with the family and up to the state, are core issues in our discussions on the nature of various communities and whether they should be allowed to be autonomous and conduct their affairs and way of life without the interference of the state. Most of this debate is framed with concepts from constitutional law. Recently, scholars like Professor Alexander, Dagan, Penny-Alver, and Shai Stern brought property theory to the fore and reconceptualized the entry-exit dilemma as one that belongs to private law as well. And my project is fully in line with this development. It asks questions regarding actual communities and their property, and about members and the property they bring into the community upon their entry, the property that they accumulate while being members, and what property are they allowed to when exiting the community, whether upon their will or due to their expulsion. In this short presentation, I will talk mainly about the exit phase, but one cannot, of course, separate exit from the previous stages. Also, I will only talk about liberal communities where membership is voluntary and exit is one of the members' rights. There's leaving some very important questions regarding non-liberal and non-intentional communities for another time. I'll begin with an example from the past and continue with presenting a series of questions that need to be addressed. Then I will use the example of cooperative societies generally and the kibbutz in particular in order to demonstrate the depth and scope of these questions. I warn you, answers will not be provided. All right. In her wonderful book, Boundaries of Utopia, published in 1980, Professor Carol Weisbrod analyzed the ways in which 4 US religious communes of the mid-19th century utilized the contract form and the then legal doctrine of freedom of contract with its minimal tendency of interference with contractual relationships in order to regulate their communities, including the regulation regarding members' property. In all of them, members transferred all of their property to the community, and in some of the commune's members accepted that none of it would be returned to them upon leaving the community. These were not merely statements or moral obligations. The contract was legally binding and enforceable either privately or through state courts. In all cases brought by former members, US courts ruled that the contract was valid and that the community had no obligation to return property and to compensate members in other ways. Weisbrot also showed that at time, despite what was written in the contract, communities did return property or gave exiting members property in order to help them in their new way. For example, as a member of the Shaker community that adhered to the idea of celibacy stated, "No person who withdraws peaceably is sent away empty." And as Margaret Melcher wrote in 1941, when a young Shaker and a Shakeress fell in love and wanted to get married, to live and get married, if they went frankly to the elders and told them of their desire, the elders put them on a kind of 6-month probation to make sure that they really knew their own minds. Then, if they still wished to marry, the Shakers let them go with their blessing, a sack of flour, a horse, and $100. So this is a lovely story. But the fate of other members was not so bright. Those who were expelled, those who disobeyed some rule, those who exercised their voice and protested while being members, left the community with nothing. Leaders of the community had power of discretion, and only the worthy livers were rewarded. Besides showing us that times might change but some problems remain the same, the case of the American communes highlights some fundamental issues regarding members' rights and duties upon exit. A common argument presented nicely by Leslie Green is that the right to withdraw from a community functions as a protective mechanism. It allows the members whose interests were harmed by the community to defend herself by leaving. In certain circumstances, the mere possibility of exit may itself suffice to make communities more responsive to the needs of the members. The liberal community is committed to the free exercise of exit for all members, and you can see in that regard Susan Moller-Okin and Ayala Chachar argument about what needs to be done in order to assure women the right of exit. If we want to guarantee free exit, it is often argued, we should not put obstacles that would prevent it. Making demands, whether monetary or other, might constitute such a barrier as it puts a too high price tag on the right to exit. But things are not so clear-cut as the liberal argument would mandate, and it goes both ways. During the period of membership, a member enjoys many rights and privileges, including rights in regard to the community property. Does exit necessitate the expiration of all these rights, or should there be some, even if limited, continuance of the right to use or otherwise enjoy some of the community assets? If members are not provided with some kind of property or compensation, doesn't it constitute an enormous barrier to exit? Or worse, it becomes some kind of a punishment. And if there is such a payment or provision of property, what is their purpose? To compensate the member? To put her in the position she would have been in if she didn't join the community? Or to help her in the initial stages of her new life? If there are remuneration, wouldn't it commodify the relationships between the community and its members and affect members' perception of what it means to be a community member? What scales of valuation should be used in order to negate such commodifying effects? Should the state intervene, either by regulating in advance and setting some requirements, or by judicial supervision over the decisions of the community? There is another side to the story. Does exit mean the ability of the member to withdraw from all duties and obligations toward the community and her fellow community members? Does a person who enjoyed the benefits of community life have an obligation toward the community, especially if there are negative consequences to one's exit, be it economic or in terms of members' sense of security and solidarity? Should we think differently about members' duties if she lives a strong and affluent community or lives a weak community in social and economic crisis? Here too we should caution ourselves in order to avoid creating too high barriers, but also commodification of relationship. And of course, should the same rules apply to members who left voluntarily and those who were expelled? Serious questions, but it's not so easy. Yet, not all communities are alike. Providing answer to these difficult questions should not be made in an abstract manner. It necessitates a contextualized thinking. We should be able to distinguish among communities by their importance to their members' ability to realize their conceptions of the good, by the scope of their demands and jurisdiction over the members, and also by the place and meaning that property has in the shared lives of community members. The commitments and obligations that should be imposed on communities and individuals, therefore, should accord this distinction. To add to that, not all assets are the same. Money, land, housing, wages, and other work-related privileges, university degrees, work experience and skills, right vis-a-vis the state, they are all different, and these differences should be taken into account. As I said, no, I will not provide answers to any of these big questions. So in the second part of my talk, I want to present the case of members in Israeli cooperative societies as a demonstration to the above-mentioned dilemmas. Why cooperatives? Because they are a modern phenomenon, an example of new modes of communities that were created as an answer for the human need to associate in times of urbanization, industrialization, increased mobility, and mass communication. Cooperatives, at least ideally, are liberal communities. So it enables me to show how complicated the issue of property and exit is, even in such communities. Within the sphere of legal forms of incorporation, the cooperative society is unique. The legal cooperative form is part of a worldwide cooperative culture with its unique history and ideology. The cooperative idea emerged in early 19th century Europe as a reaction to the domination of aggressive industrial capitalism. The cooperative idea aims at collective action for the improvement of the economic, social, and cultural condition of its participants in accordance with the principles of democracy and equality. In contrast to the more prevalent mode of legal economic incorporation, the company form, a cooperative aims at more than gaining profits. Cooperation among its members is not merely instrumental, but a goal in its own right. The cooperative promotes values such as social solidarity, social responsibility, and community affiliations. The Western ideal of cooperation has become as some fundamental tenets, the most important of which are democratic governance according to the rule, one member, one vote. And what is of importance to my presentation, membership should be open to all, entry is voluntary, and members enjoy the right of exit. There are many kinds of cooperative societies. Sociologically speaking, we can talk about two ideal types: the corporate type, cooperative, and the community type. The corporate type is characterized by more instrumental relationships among the participants, by the limited scope of the mutual interest of the members, and by its hierarchical structure and formal mechanism of decision-making. On the other hand, in the community type, we find a dynamic social life of members with diverse and overlapping mutual interests and many face-to-face encounters as part of their everyday life. We can situate every legally registered cooperative somewhere on the line between these two poles. So the question is, how are we to regulate the property relations between the cooperative and the members who wants to live? Israeli law provides us with a good starting point. Let's first look at the more corporate-like cooperatives, such as workers' cooperatives in various areas of production and services. While members are required to work in the economic enterprise, their legal relationship with the cooperative is not one of employer and employees. Every member buys a share issued by the cooperative, and is entitled to participate in the cooperative collection decision-making, to vote and be elected to the governing bodies, and to receive a dividend if one is distributed among the members. Membership in such a cooperative is personal, and the member cannot sell or otherwise transfer her share to another. When a member wants to leave the cooperative, there is a process of redemption. The cooperative must pay the member the market value of her share and is allowed to deduct any debt owed by the member. Although the cooperative differs in its tenets and its practices from the company model, in regard to members' rights, when leaving the cooperative, market rationality is applied. Variables such as the reason and circumstances of leaving the cooperative, how many years was a person a member of this community, was she a valuable and appreciated member, what are the stakes for her outside the cooperative, to what extent did the membership enrich the member with skills and work experience, all of these are completely not taken into account. It is a formal, equal, and objective arrangement, and it has its good sides. But it seems that it undermines the unique character of the cooperative ideal and the basic wish professed in it for the creation of a community of people and not of capital. Now let's turn to the fascinating case of the ultimate community-type cooperative society in Israel, the traditional kibbutz. And I'll have time only to talk about the traditional, but I'll follow Bernadette's example. Please ask me about the renewing kibbutzim. All right. So the traditional kibbutz is a special case of common property holding and communal way of life for people pursuing ideals of equality, liberty, fraternity, and mutual assistance. Its members hold and manage all property, means of production, housing, and other consumer durables together, and share its benefits equally with no direct link to their labor or any other contribution to communal life. Private property holding is generally prohibited, and all income, including the salary received by members who work outside the kibbutz, goes into the common purse. At the same time, the kibbutz provides for all the needs of its members through a system of collective consumption, which constitute what is known as the mutual guarantee for all members. Okay, I'll skip that. In stressing the non-commodified aspects of interpersonal relationships within the kibbutz, it offers an alternative to the market, in particular the traditional kibbutz ban on private property and its commitment to mutual responsibility and the equal value of members' labor are an antithesis to market ideology. So we may characterize the kibbutz as a liberal commune. Both entry and exit are voluntary, with the exception of expulsion that is rather rare. When the first kibbutzim were established in early 20th century, their members had no meaningful personal property, and the kibbutzim were themselves impoverished. Add to that the strong ideological convictions, so it is well understood why members that chose to leave left with nothing. There was nothing to take with them. Later on, kibbutzim were more economic sound. At the times, joining members had some property. Thus, the need to set rules to govern the matter emerged. But every kibbutz had its own rules, or every kibbutz movement has its own rules. Only in 1963, the state intervened with the cooperation of the kibbutz movement, and general rules regarding entry and exit were set. The new and general provisions under state law provided that each member that leaves the kibbutz, whether on his own will or being expelled, is entitled to two kinds of payments. First, a sum to be paid upon leaving the kibbutz according to a mathematic formula that basically says this. Take the amount that constitutes the basic general budget members receive in the specific kibbutz and multiply it by the numbers of years a person was a member, then add another sum for each minor child. The second payment was to be paid when a member would celebrate her 67th birthday, and it resembled payment from pension funds. The member is also entitled to take with him all personal property in his use that was provided by the kibbutz. So this formula is equally applied to all members, no matter who they are, what they contributed to the kibbutz, or whether kibbutz supplied all their special needs. The kibbutz continue to contribute to members' welfare outside the kibbutz in old age, whatever is their economic situation. So this arrangement is not based upon market rationality, but upon the standard of living in the specific kibbutz. Does the property arrangement upon leaving the kibbutz adhere to the unique norms of kibbutz life, way of life, equality among its members, and the equal worth of members' contribution? So I won't go into that, but of course when the kibbutzim changed and market rationality became the basis for organizing their lives, everything changed in also regarding the rules upon exit from the community. So we see here a process where the kibbutz that was at the outer pole of the community, like cooperative, turned more towards the corporate way, and it affects everything. The relationship between the members while being members, and of course upon their exit. So we see here how the different schemes or arrangement differs. However, and I'll end with a question. What brought the change was a major economic crisis in the kibbutzim. And during that crisis, many members left. Some of them were prominent and leaders of their communities. The kibbutz was basically bankrupt, but it had to continue paying the members who left. So I want to come back to the question I posed before. Does exiting members has no obligation towards the communities they live? And should we limit it or tax their, not their right to exit, but the consequences or economic consequences of their exit? Thus, we give full attention to the real meaning of being a member in a community that its tenet was, we take care of everyone. And by living without or getting free from this obligation, does it really adhere to our liberal notions of the right to exit? As you can see, I think there should be a tax on it, but we'll talk about it. All right, thank you.